Thank you very much, and I really want to first of all acknowledge and thank the organising committee for arranging such a fantastic event, in particular the O.P.E.M.E.D and the Hellenic Mediation Chamber of Commerce. I've been asked to speak about family mediation, but what I'm also going to be doing is talk about the implications that family mediation can have on commercial practice. As a family mediator and also a commercial mediator, I recognize and realize that they can both learn from each other. One of the challenges to any system is always how people are going to adopt this. And what I'll be talking about is how people and the community have accepted family mediation in England and Wales, and how really you can learn from some of the issues that they've had to deal with. Well, as we know, mediation is voluntary, impartial, confidential, and really it's about the parties remaining in control. And in particular, it's about the ability for people to come to a resolution and come to a solution, particularly when you're dealing with some very fraught and very challenging situations and circumstances. My colleague spoke about, from the Netherlands, he spoke about the adoption and the use of mediation in the Netherlands, and certainly around the world, family mediation has certainly been used systematically. One of the things that people have also said, and those users have said, that actually it gives children a voice as part of the mediation process and as part of the resolution for the dispute. One of the things that was really interesting is that the BBC commissioned a documentary, and if you are watching this and you have the ability to click on the link here, there is an interesting link to the documentary called Mr. and Mrs. Call the Mediator series, which actually documented and followed a number of real-life individuals who are actually going through a divorce and separation, and how they use the mediation process to find a resolution to their dispute. They were very brave, and there were some very fraught discussions, but you can see how mediation has worked for them. In England and Wales, they have really spearheaded how to adopt and use mediation. And in order to do that, there needs to be a partnership between the legislative branch, the judicial branch, and also commerce. It started off really with the Family Law Act of 1996, followed by the Access to Justice Act, then the Legal Aid Sentencing, and then last but not least, the Children and Family Act of 2014. They also saw that they needed to have an overarching body, such as the Family Mediation Council, to provide competency, and also to provide an overarching body to provide guidance and also conversations with government. Family Mediation Council is regulated by 6 mediation organizations and provides a code of practice for family mediators and sets a minimum standard for practice requirements of family mediators, something that the commercial world doesn't actually have. In the commercial world in England and Wales, we have the Civil Mediation Council, but they don't have the same strict requirements that they do under the family mediation system. The Family Mediation Council also has an agreement for who can be a family mediator and what the requirements are. Something, again, that the Civil Mediation Council has, but not necessarily the same strict requirements. There's also a good link and a good dialogue between government and also other bodies that are interested. And so it's the Family Justice Council that's been introduced, which is a non-statutory advisory body which really monitors the effectiveness of the system. And I think it's about this partnership and this ability to have a dialogue between many of the different systems. As we said in the opening remarks, that there are in Greece, there were 21 advisory institutional partnerships. It's about having the link between all the various different agencies, and really it's about how can you best implement a system. One of the main requirements of the 2014 Act was a requirement that each person had to consider the use of mediation. Now, there's always a question about should mediation be mandatory or should it be voluntary, and I think my colleagues would probably speak to some of that. The question is that do you take the voluntariness out of mediation if you require individuals to at least go to an information and assessment meeting? What is required in order for individuals to continue a contested divorce in England and Wales? They must first of all attend what they call a mediation, information and assessment meeting. Now, this is where individuals will be given information about mediation. They'll also be assessed as to whether their case is appropriate for mediation. There are strict requirements about what cases can and cannot be considered for mediation. Basically, what mediation does is it provides information in a very safe environment. And the mediator will provide information about what mediation is. It will start to clarify the areas where there are disputes and provide options for resolving them. And if you think about that, then if you use it in the commercial world, maybe this might have some application. And also via other sources of support, including other financial and emotional and legal support. Ultimately, it provides people with information, and people need information, particularly at this very difficult time when they're trying to resolve the conflict that they're facing. How are they going to deal with the children? How are they going to separate assets? And how are they going to divide their lives that were at some point were so intrinsically bound? And you think about that really when there's dissolution of partnerships for business, or if there's a commercial breakdown in relationships, that people need sometimes the same information. Now, there are certain exemptions which are for individuals who will not necessarily have to go to a mediation information meeting if there's issues about domestic violence, bankruptcy, unavailability of individuals, and if people have already attended a mediation session 4 months earlier. Now, the question is, who pays for this and how much does this cost? One of the things is the government recognized that people need to have the ability to afford to go to mediation. And so people can actually apply for legal aid, which means it's publicly assisted mediation assistance. Now, again, there are strict requirements about who is and who is not eligible for mediation. And always when individuals are introducing mediation into a new system, there's a question of who pays, how much is it going to cost, and also how do you professionalize the system. The legal aid agency has certain requirements, and they have contractual arrangements with various different providers. They provide cases for the following issues: that if there's a contract arrangement, residence and parental responsibility, child maintenance, property, and financial arrangements. They will provide legal aid for the mediations for those particular cases. Anything else, if it's purely about dealing with disputes and it's not under those 5 areas, they will not fund the mediation. This is what the mediation contract would look like, and mediation providers would apply for a yearly reimbursement. Now, the question is, does this work? Now, people are always looking at numbers and always looking for sort of proof points. As you can see here, that to go to court for a contested divorce takes around about 435 days. Now, when you're in dispute, and if you imagine what that's like, that's a long time. For a mediation, it can take as little as 110 days to complete the whole process. That's a quarter of the time. And you can imagine for people who are in dispute and who are challenged, that sort of opportunity for relief is essential. Then there's a question about how much does it cost? Well, a case going to mediation costs a mere £535, where going to trial can cost at least £2,823. And again, these are average amounts. Not every case is going to cost that. Sometimes cases are more complex and sometimes more simple. And according to the Ministry of Justice reports, almost 2/3 of couples who attended a single mediation session of a child dispute reached a full agreement. Now that's staggering. 2/3 reached resolution after one meeting. And imagine if they didn't go to that meeting, they wouldn't have that opportunity. So you can imagine if people who are in dispute for a commercial case that have the same fraught situation have the same emotional entanglement. If they have access to potentially mediation, potentially they might find resolution as well. And also, couples who reach an agreement, 7 out of 10 cases are satisfied. That's remarkable. What is also required is, well, we've got mediation, we have mediators. The question is, how do people know about this? So the Family Mediation Association have introduced things like Mediation Awareness Week, and I think in a number of different jurisdictions, both locally and nationally, information sharing and promotion is essential. And I think in any system, particularly if you're thinking about how you can disseminate information in Greece, through business people, through the ministries, through the individuals who are going to be the users, it's saying demystify what is mediation, what can it do, and what can't it do. Because ultimately, you want to think about how can the mediation from various different sectors inform each other. So here are some of the implications on practice for the commercial world in England and Wales. The question is, how voluntary is mediation currently? At the moment in England, those individuals who do not consider some form of dispute resolution may be sanctioned for costs if they're the prevailing party. So there's always a question about voluntariness. So maybe what they should have is that all cases for a certain value or a certain level of complexity should go to a mediation session, have information, and be assessed the same way that they are in family cases. Now, should the government be more involved than it currently is? There's currently no mediation law in England and Wales, and there's no currently statutory regulation. So maybe there should be some regulation similar to other countries such as in Greece and other civil code jurisdictions. Potentially by doing that would require individuals to be far more aware and far more, they would be sort of geared and steered towards using mediation a bit more. Then of course the question is that mediation in England and Wales is trying to professionalize, and there are, of course, a cadre of mediators who charge quite a lot of money for mediation. So the question is, who pays for mediation, how much does it cost, and should there also be some sort of legal aid assistance? And then, of course, the difference between how the Family Mediation Council regulates its body versus the Civil Mediation Council. Should there be greater oversight? And then also, who should be the mediators? In England and Wales, anybody can be a mediator. They just have to have some training. In fact, in some cases, they don't even need to have that. And ultimately, last but not least, the proof is in the results. It costs a lot less money to use some sort of dispute resolution than to go to trial. And do people actually know that? I'd like to again thank the organizers of this wonderful conference. In particular, I'd also like to recognize the Hellenic Mediation and Arbitration Council, who really tried to spearhead mediation in the commercial world, and also recognize their partnership with the Centre for Effective Dispute Resolution in London. And again, I'd like to thank the invitation from the British Hellenic Chamber of Commerce. Thank you very much.